Your inherited property is subject to being split in a divorce settlement if you mishandle that property. So the two main ways that people will mess this up is they will use marital funds to pay for things like renovations, repairs, maintenance, mortgage, utilities, taxes, etc. on that inherited property that is separate. The other way is going to be that they will receive that inherited property into their personal name and then retitle it to be jointly owned with their spouse. Those two things will allow that property to be split in a divorce settlement. So if you want to maintain ownership over it, don't use marital funds to pay for it in any way and keep it in your name only. Now, if you do want to make sure that your surviving spouse does receive that property in the event that you pass away, you have a couple different options on this. The first one is going to be that you can put into a will, list that on a will that your spouse would receive that property when you pass away. It will still have to go through the probate process. Another one is going to be using a transfer on death deed. You would maintain the ownership in your personal name, but will be able to avoid the probate process, go directly down to them. Another one is going to be using a revocable trust that will allow it to avoid the probate process, and then you can use it to take care of your surviving spouse in the event that they need it, and then pass it down to your kids and avoid the probate process both times. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to some more on our team.